And I'm going to now talk about basically what happened in the case and how we figured out the involvement of Gorton in the complaints that we had, that the LSB had received, based on which they investigated us. So, firstly, the LSB's gripe with me basically started because I was making a lot of complaints against lawyers. I had companies that were involved in litigation extensively, and when lawyers acting on the other side were committing breaches of the uniform law, it was a policy that we would meticulously document those contraventions and make complaints against the LSB. Again, I was interested in developing conceptual frameworks to hold public authorities to account, and what I was doing was part of that. So the LSB was getting annoyed, and it understood that I would continue doing this, forever, unless something were to change. At the same time, so I was spending a fortune on external lawyers at the time, and the problem was that I was still writing everything that I wanted them to do, but the process was very inefficient and unnecessarily expensive. So I had started working with Peter Kennedy, who was the founding partner at Matrix, and he was helping me set up my own firm, initially through in-house lawyers, and then registering it as an ILP. So it took us a while to achieve the setup, and the efforts were impeded by the COVID-19 outbreak as well. But essentially, even before I'd set up the firm, the LSB, I'd come to the attention of the LSB because of the complaints that we were making. The other thing that we were doing at the time was we were trying. So what I was saying is that the problem with the LSB had started prior to the setup of the firm, and the other aspect of the work that we were doing was because I wanted a consistent standard across things. I was getting the lawyers to generate templates for everything that they were doing, and basically generate templates for every possible scenario of contentious activity that the businesses could conceivably get into. And this was the only way I could sort of implement a standardized process. Now, during the pandemic, one of my businesses had disputes with 3 people out of over 1,000 contracts that it had, the freight transfer company, that year. And these people, each of them was from a different state. A current affair wanted to, sensationalize the thing, and they did an episode about it. And one of the things that because the core dispute was very boring, they sought to sensationalize the matter by bringing my name into it and talking about the fact that I have, a lot of litigation on. And then they tried to make a big deal out of the fact that so the lawyers that the businesses had engaged, they had contracted sole practitioners to work as general counsel, and this was done under a dedicated corporate entity that would then invoice the other entities for the services of these lawyers. Now, the uniform law specifically states that if an entity is only providing services to related entities, it cannot even register as a law firm. It's not even eligible to register as a law firm because all your lawyers are basically corporate lawyers. Their practicing certificates are corporate certificates. What the current affair idiot tried to do was he alleged that entity that was billing the other entities for the services was a fake law firm because it was never registered to practice. So the lawyers that were working had practicing certificates. They had their own businesses. They had been contracted by this entity as a billing arrangement, basically. So their billing would be consolidated in one entity, and that entity would then dispense out the bills to the various entities depending on their consumption. Now, he tried to misrepresent that. The LSB obviously would have known better. I mean, that's how they use Gordon Cooper, basically, without any instrument of delegation or anything. The second thing was that what he tried to imply was that because I had been responsible for approving the templates that had been created, even where the lawyers were writing to the different parties, it was basically me writing in the name of the lawyer. And then he tried to basically blur the line and imply that I was using fake lawyer names. So what was actually happening is that I was overseeing the work of the lawyers minutely and checking things and making sure that what they were doing was right. And I tried to use as much standardization as possible. So he tried to misrepresent that as if I was, doing that without the consent or knowledge of those lawyers. Now, Howard Bowell's the idiot. He basically, the moment he heard these allegations, without even checking, without speaking with us, he immediately commented and said, this is a serious matter, we will investigate. Now, I was already setting up the business to sue government entities, and I had a fair amount of knowledge of the administrative law provisions that applied in these cases by then. So the first thing that I decided to do was sue the LSB for breach of the public sector guidelines, communication guidelines in this matter, because they commented, they could have only commented if it was a public interest matter. And for that, they were required to conduct some preliminary investigation before they could know that. So anyway, this was the time when the setting up of the law firm was being finalized, and a person called Ronald Gordon was initially recruited as the principal solicitor. He had misrepresented himself as, an administrative law guy, and, that he was very interested in learning and blah, blah, blah. So he basically wanted a cushy thing where he bossed other people around, and that wasn't going to work with me. So the first thing he was involved in was actually suing the LSB or sending letters of demand to them and a concerns notice. And the second thing was the defamation matter against a current affair. Now, he had even briefed barristers to commence the proceedings in the federal court. Now, a couple of months pass by, he's not doing well, and I literally have to draft every document that he was supposed to draft from scratch to show him how things are done, and it's really not sustainable. So I have a chat with him, and basically the first week or so, he stayed in the office until 11. I used to basically live at the office. After that, 2 weeks later, he's going back home at 4:45 and doesn't want to. He's really bad. Also, he doesn't want to learn. Whereas our deal was that one, he had a working knowledge of those areas, and two, that he would really invest himself in learning about these things, because the whole point was to create a very technically adept firm that focused on administrative law and suing government bodies. So when it becomes clear that it's unworkable and he's not going to make an effort, I told him that I was going to get a replacement, but I expected him to cooperate until then. Otherwise, I would sue him until he was destroyed or every court had rejected me. He got really scared. The next day, he came into the office at 7 a.m., stole some files and gave them to the current affair guy. He was caught on camera while doing that. At the time, we had, on average, 3 other lawyers, depending on who had been fired that day. But one of those lawyers had been exclusively recruited for cost-related matters. He had applied to us through Indeed. This is Alan McGregor. Alan was 70-something at the time, and he had applied to us for a junior lawyer's position. And he'd made 2 applications, one for a junior lawyer, one for a paralegal. He had a principal certificate. Basically, he didn't have any work. And we had decided to use him purely for processing, creating the bill of costs for the different matters that we were involved in. And if the matters went to, cost court, then the idea was that because of his experience, he'd be able to deal with it on his own, and this way we could focus the other resources purely on litigation. When Ronald Gordon did what he did, so we saw him on camera stealing the files and so on, so he was fired that day. And then there was the problem of who's going to be the principal solicitor immediately. So because Alan had a principal practicing certificate, he was appointed as the principal solicitor that day. And then we started looking for a replacement for Ronald Gordon. Now, that's the time when we are, shortly after, we were involved in a proceeding that came before Gorton. And this was a dispute about the office premises that the firm and a related entity were renting. Basically, the owner of the property took the view that because under a corporate lease agreement, there wasn't any right to having the place functional in every respect. It was discretionary for him whether or not he conducted repairs on time or not. So I stopped paying him, and he then basically, I did that to create inconvenience, so he would be pressured into conducting the repairs quickly. Normally what I would do is I would pay them just enough so they don't meet the technical requirements for issuing the notice to vacate, or pay them right on the day they issue the notice to vacate, just the arrears, and then drag it out until they conduct the repairs. So that's what we were doing. We complied with every technicality that was necessary. What the asshole did was he started charging us a fee for issuing the notices to vacate, which was completely unlawful because it's a penalty, which people cannot charge. So that was the case at VCAT. So what he started doing was, when we would pay him the fee, he would say that, that's the penalty, that's basically the arrears that you owed us from issuing the notice to vacate. So now you're in deficit. So based on that, he tried to get us to vacate the premises. The VCAT member was an idiot and didn't understand the concept of penalties. Ronald Gordon, by the way, appeared in the matter, presented the case, and argued the penalty thing. This was the first hearing, and then there was another hearing. By then he had left. So I did the second hearing. Now, when the member was being an idiot, and she forgot some things that had been agreed between the parties during the first hearing. So I produced a transcript of that first hearing, and the barrister on the other side said that the member should not look at the transcript because I have caused the hearing to be illegally recorded, and then produced a transcript of that recording. And basically, she should not look at it because it's the product of, a criminal offense, because recording proceedings is a criminal offense. He said that purely on the basis that the transcript carried the logo of the firm, because it was a document of the firm. The member did not look at it. He had misrepresented an agreement that had been achieved between the parties during the first hearing. And the member didn't remember it. I was specifically calling it into evidence. She didn't look at it because of that. Now, the WCAT does not release transcripts. They only release audio recordings that you then have to transcribe through different parties, or you can do it yourself. We had given the other side a copy of the transcript 4 weeks before the hearing, and the audio recording as well. Also, the member had herself approved the release of the audio recording, which they're required to do. Despite all of that, she basically instinctively accepted his submission. So we lodged an injunctive relief application. Gorton was the duty judge. It came before him. And the hearing it took place at around 9 at night, and he gave us an injunction. This was done on the basis that the proceeding hadn't started yet, but there's a procedure pursuant to which the court can hear an application as if the originating documents have been filed, grant an injunction, and then give a limited time within which the originating documents should be filed. So that's what Gorton did. Now, we had, I think, 3 or 4 days to lodge the originating documents. And before we could do that, so I presented the case that evening. Alan McGregor introduced me as the client, or the owner of the client. And what we said was that Alan wasn't familiar with the case. I had presented the case at WCAT, and he's recently taken over from Ronald Gordon, and basically he didn't have enough time to apprise himself of the details, so that's why I'm presenting the case. And Gordon was super cool with it. In the interim, the other side basically filed an affidavit which set out, the various disputes that I had previously had with other WCAT members, and the critical comments that they had made about me. Now, I'm famously very direct with judges, and my favorite joke is what happens if you punch a judge in the face? They have to go to a different judge to whine about it. It's about the democratic process and everybody being equal and so on. So these people put all of those things before Gorton. Gorton got prejudiced, and what they were saying is that I should be prevented from presenting the case on behalf of the company, because it's up to the court's discretion. So the moment they filed those documents, I made an application to exclude the evidence because it was unfairly prejudicial, and it was what is called tendency evidence. And there's a very high requirement for the introduction of tendency evidence under the Uniform Evidence Acts. And basically the criterion is that you can only introduce tendency evidence if there is no other explanation that's reasonably available to explain the conduct of the person. It's a very high threshold. So I argued that before Gorton. Gorton basically said that you're not a party to the proceeding, and your credibility is not necessarily in question. They're only attacking your position as in the context of whether or not I should give you the indulgence to represent the company. And he said because he has unfettered discretion in that sense, the Evidence Act effectively would not apply because it's outside the scope of what it was conceived to do. And I tried to explain to him that firstly, I may have to give evidence in the proceeding, and then he would have basically assessed my credibility in an adverse way. Secondly, it's basically hearsay, what they're relying upon, and this was common ground that it was hearsay, because it wasn't part of the judgment. What they were doing is, I had skirmishes with these idiots at RECAT where I was criticizing them for not knowing the law, and they were basically talking back at me. And they had introduced that into evidence, and there was no basis upon which it could be accepted as a record of orders that were made or whatever, because it was not reflected in the orders. And so it was purely hearsay, and those people were not coming to give evidence, and I had the right to present contrary evidence. So Gorton did not allow me to present contrary evidence because it would have taken too long. He allowed them to rely on hearsay evidence because there is a rule, there's a law or section of the Evidence Act which says that in interlocutory proceedings or hearings, you can rely on hearsay evidence if there's a lot of conditions, none of which was met. But anyway, he allowed them to rely on that only in relation to the question of whether or not he will give me the indulgence of representing the company. He did that whilst accepting that there was no basis to rely upon that as an accurate account of what had happened, and on the basis that he accepted that I had a perfectly good explanation to explain the events in a way that was, at worst neutral to me, in the sense that I was not at fault. He said that the only thing he was considering, though, was that it could not be said about me that I had represented companies without incident. Literally, it's in his written fucking judgment. That's how stupid he is. He said that it was only relevant because the inference that he drew from that was that it could not be said about me that I had represented the companies without incident. Now, this sounded really stupid, and this was not the only thing he was doing. The other thing he was doing was that he was stopping me from suing the lawyer on the other side. His rationale was that ultimately it was the member that made the order. You don't need to sue the guy to reverse the order. You can just say that the member made a mistake, blah, blah, blah. Why do you want to, destroy someone's career? He understood why I was doing it. He accepted that the other guy had basically breached the uniform law. In fact, he had even admitted that. So right after the hearing, after I sent him a letter of demand, during the hearing, I put him on notice that I would sue him. So by the end of the hearing, the other side, the solicitor for the other side, had sent me an apology letter and sent a letter to the tribunal apologizing for the allegation that had been made. So it was fair admission, and Gorton noted that. And he said, you have every right to be offended, blah, 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 but, this is not how things are done. You should just go for the conventional relief. And the other thing, when I basically said no, he couldn't stop me from doing that. Then he said, I wouldn't be comfortable having a non-lawyer make the allegation against a lawyer. This is all on transcript. And then he was like, a lawyer should be making these allegations if they need to be made, so on and so forth. So ultimately, I rebuked him for being an idiot, and I challenged him to point out a section of the Evidence Act that allowed him to introduce the... So essentially, at that time, Gorton and I had some unpleasant exchanges. Gorton was upset about it, and he made an adverse cost order, even though I won the application at the time, just to express his dissatisfaction about it. Now, the second proceeding that Alan McGregor was involved in was a proceeding in the federal court before Wheelahan, Justice Wheelahan. Now, that's how we realized that Alan was really senile, because what was happening in that matter was that he would appear in the hearings and then basically lose track of what had happened previously. And, you know, he would prepare for the hearings, go through the documents, but be completely blank. This happened a few times, and Justice Wheelahan was getting very impatient with it. There had been delays in the lodgement of documents, and that was because of Ronald Gordon's shenanigans. Anyway, at one point, Justice Wheelahan made an order requiring the principal solicitor to affirm an affidavit about the steps he had been taking to comply with the orders that the court had been making, because he had missed a few of those. So I called Alan in to instruct him about the affidavit. And as the client, I told him that he should note in the affidavit that the client thinks that what the judge is doing in making the order, the judge has failed to consider that in detailing the steps that the lawyer was taking, he would inevitably be forced to reveal or disclose legally privileged information. And therefore, he had acted contrary to his requirements to uphold the substantive law in relation to client legal privilege. So that was the part of the affidavit which was critical of Justice Wheelahan. Now, Alan was given a draft of that affidavit and to affirm it, and basically Ronald Gordon had started talking to Alan McGregor to influence him, because I had a proceeding live against him in the Supreme Court for breach of confidence and so on and so forth. So he was trying to influence Alan, and Alan was obviously senile and getting affected. So he wrote to the judge's chambers to check if the orders requiring an affidavit be filed were actually made, because he had forgotten that the orders had been made. And he basically wanted a copy of the orders from the judge's chambers. And he wrote without telling us, and provided a draft copy of the affidavit that, you know, we had, that basically a paralegal had drafted up for him based on the discussion that we had when he was in office. Wheelahan provided that to the LSB in the sense that, you know, the lawyer is not able to function. And that's when Alice Duggan, the same day, Alice Duggan appointed Damien Naylon to conduct an audit into the affairs of People's Shop. The problem was that the way in which Wheelahan had done it was not a formal complaint, and the uniform law only allows them to appoint an auditor in case of a firm that does not operate a trust account if there is a complaint, either a consumer complaint or a disciplinary complaint. So there's a lot. This was on the 9th of November that had happened. Now, we make a formal complaint against Alan to the LSB on the 16th of November. They acknowledge it on the 17th of November. On the 18th of November, they write to Alan and they tell him that the auditor has been appointed, and they imply to him that he's been appointed because of the complaint that we made against Alan, and that if he doesn't cooperate, then he loses his license because of the complaint that we're making. And that's how they get him to basically cooperate with them without telling us. Now, they then call us about the complaint that we've made against Alan. Maria's coordinating with them. And they're basically asking, how we're managing the affairs of the firm in the absence of Alan and so on and so forth. So what they're trying to do is bring in the angle that you don't have a principal solicitor, and therefore we are going to conduct an audit, or you need to stop functioning. Now, all this while we're conducting recruitment, and we had agreed with the LSB that by the 3rd of December we should be able to find a replacement, which was to carry on the thing. Now, it's important to note here that Alan was still employed. So it's not that we didn't have a principal solicitor. The law only says that you cannot operate without a principal solicitor being employed. So the principal solicitor that we employ or that we agreed to hire on the 3rd of December is a person who had stopped practicing while he was overseas. He had had some issues in the past, but he hadn't told us about those because he didn't think it was relevant. So when he sought to renew his practicing certificate on the 3rd of December, they refused to renew it. And then they wrote to us and said that you don't have a principal solicitor, and we've appointed Damien Nailon because you don't have a principal solicitor. So the same guy, Damien Nailon, appointed on the 9th of November, they tell Alan on the 18th that he's appointed because we made a complaint against him. They tell us that he's appointed because we don't have a principal solicitor. And they haven't given anyone the notice of appointment yet. So we're, still recruiting. We needed more than one lawyer anyway. So that's when Peter Ansel and I get in touch. We needed urgent representation, and Peter helped us with that, I think on the 2nd of December, or thereabouts, 2nd or 6th of December. And after he had appeared for us in federal court, we basically told him about what the situation was in relation to the principal solicitor that we had hired, that his practicing certificate was not being renewed immediately, and we needed someone to continue operating the firm. So Peter agreed to be the principal solicitor until we could find a permanent replacement, and he was appointed on the 10th of December. So now the LSB had a problem because they could no longer use that excuse to do the audit. So on the 10th of December, Peter was appointed. We notified the LSB on the 13th of December. And all this while, there are emails being exchanged every day between us and the LSB. And, it's getting increasingly contentious. And we're gearing toward suing them because they're putting a lot of pressure and saying, give us all the files. Give us the details of every case you have, every barrister you've instructed, and every person who's worked for you. Like, completely fucking idiotic. And we don't even know what the scope of the audit is yet. No details have been provided. So our position was that we suspected Ronald Gordon to have leaked information about all the things that we were doing to the LSB, which, by the way, they confirmed later on. And also the fact that Howard Bowles, that I was developing a case against him. And that's why they wanted all the documents, so they could understand what evidence we had against them. So on the 13th, we write a very aggressive letter to Alice Duggan, who was the person responsible for dealing with our case. And we tell her that, one, we've appointed Peter Nailon. We demand that they give us the notice of appointment for Damien Nailon. We tell her that we've appointed Peter Ansel as the principal solicitor. We ask for evidence about we ask for the notice of appointment. We ask for the all the facts pursuant to which he has been appointed, and so on and so forth. And we put them on notice that we will sue them for misfeasance. in public office and abuse of authority if we are not satisfied. So this is on the 13th of December. On the 14th of December, they write to VLSB and they say that they need a complaint from him, like a determination or some complaint based on which they can take action. VLSB forwards that letter to me and basically tells them that if they want to raise issues about misconduct and so on, they need to do it in open court. So now they're fucked. And they're fucked also because I know now that they don't have anything, because they wrote to VLSB right after I threatened them. So at that point, they contact Gorton and Forbes, who were the two Supreme Court judges that Alan had appeared. Well, he hadn't appeared, but he was supposed to appear, but didn't actually appear. Before Forbes, what had happened is before Forbes, it was injunctive relief in relation to Ronald Gordon and Sam Kuchiyara and a current affair about the publication of privileged material. Now, I had represented myself and Alan had represented another director of the company, Maria. And Alan's involvement was limited to saying, good afternoon, Your Honor, and then at the end, I endorse Mr. Cooksal's submissions. That's all he was doing. So no one could complain about his conduct. Now, the LSB has already told us that they had written to all the courts, as early as April, to tell them that I was basically producing the documents that the lawyers were purportedly producing, and that in their view will have implications for the lawyers' obligations under the Civil Procedure Act. So we knew then that they would have communicated. Now, our proceeding against the LSP was actually allocated to Justice Ganey, who was orthodox and very reluctant to easily make declarations against government officers, but he's a proper judge, or His Honor, well, he's a reserve judge still, but I had respect for him. He was the head of the list, he knew the law, and as ideologically opposed to the aggressive declaratory relief that I was seeking, as His Honor may have been, I knew that he would not break the law to proactively pursue his ideology. And when I say break the law, I mean he made a lot of legal errors, and some of which he conceded even, but it wasn't driven by malice. It was, genuinely, even where I know that he would have known better, I know how much he struggled and to, resist what I was asking him, and it wasn't easy. And anyway, there wasn't active malice, and he made plenty of determinations against the LSP, and he had no problems putting all the allegations against the LSP in his judgment and setting out what needed to be done in the matter. The problem was that His Honor was due for retirement in August 2023, and there was 3 or 4 proceedings that we had against the LSP and Victoria Police and so on, that all went to him at the same time, and he prioritized the Victoria Police ones first, and he basically gave the other ones that hadn't even been started, we didn't know what was going on with them. Stephen Walters told me that Justice Ganey has a brother. Well, I knew he has a brother, but he told me that his brother was best friends with Rapke. I didn't know that, but in any event, His Honor didn't do anything at the time, which made us... he didn't actually hear the matter, so I don't know whether there was a conflict, but I trusted His Honor to be upfront if there would have been a conflict. Until the last day of the hearing, which was on the 17th of August. This is the hearing against the LSB, the first one, first substantive, which is not before a judicial registrar. We didn't know who the judge was. We kept writing to the list, asking for the name of the judge. They wouldn't tell us. Like several hours before the hearing, they tell us that it's Gorton. Now, if I knew it was Gorton, I would have applied for his recusal. Now, we've already waited almost a year for the matter to come on. The LSP has pulled every fucking trick that they can to get the Prothonotary to delay the listing of the matter. And then Peter and Lulu are very anxious to have the matter move forward. I am too, but I will make every application that should be made. And they were reluctant to start making recusal applications against Gorton based on previous experiences, and they thought he was a judge and wouldn't, be a complete scoundrel. So they wanted us to try with him first and let him prove himself or one way or the other, and then we proceed. Anyway, the first day, the issue that he has to decide is whether the judicial registrar made a mistake when so what had happened is, when the matter was being listed, we had filed a summons several months before the hearing, and the LSB filed summons a few days before the hearing, like 2 or 3 days, did not serve the summons on us. And basically the summons said that our proceedings should be dismissed without identifying why, except that they thought that it was scandalous that we were accusing the LSB officials of engaging in a perversion of the course of justice. Because they got the Channel 9 cameraman into the office and recorded the contents of the files and so on. Everything factual. So they don't serve the summons on us. When the hearing comes on, I oppose the listing of their summons because it's obviously an attempt to dismantle to disrupt the progression of the matter, because the first thing we wanted in terms of the resolution of the matter was the determination of 3 separate questions in the proceeding, which had to do with the appointments of the 3 people, Nailon, Rapke, and Gordon Cooper. And what they wanted was a summary dismissal of the entire proceeding, which was much wider. Now, the problem with that was, if we technically, because they were asking for the summary dismissal of the whole proceeding, we would have had to cover ground for the whole proceeding, which would have meant that the 3 questions could not be prioritized as separate questions. And we were basically conducting the whole thing in a slower way, and it would have taken too long. And we wanted quick resolution because Peter's practicing certificate had been retroactively cancelled after he had started the proceeding. So, like Thomas is familiar now, they basically brought this application to impede the flow of our application, which we had filed much earlier. And they did not. So I opposed the listing of their summons because it had not been served, and there's an explicit rule that you can't list summons if, you can't even hear summons that have not been served. And the fact is that a judicial registrar has no authority to to supersede the rules through his decision. Only a judge can do that. So I basically opposed the hearing of their summons because they had not been served. The judicial registrar asked them if they had not been served, and they implied that they had been served. And then the barrister, by the way, Sanathi Raja Casey, he basically said he would have to check and get instructions. I said, well, have you filed an affidavit of service? And he said he'd have to get instructions, and he never got instructions. And so the judicial registrar basically said that what I can do is, one, either adjourn the matter, next month, and we have been waiting for this desperately, or I can make orders on the basis that they have served the summons with liberty to apply. So I appealed his decision because it was fundamentally wrong and in denial of procedural fairness. Gorton comes on the first day. What he has to do is hear the appeal and decide. And, right from the start, he says, well, they did the wrong thing. They should have served the summons. And yes, it denied you procedural fairness and blah, blah, blah. But then he says, well, but also you should have put up with it. Because, ultimately, what difference would it have made? He says, their matter should have been listed as well. And we're like, you just said that we were denied procedural fairness. He says, yeah, but, big deal. Like, it was just a summary dismissal application. Everybody has a right to blah, blah, blah. And I said, no, they don't, because it's a fundamental... I said if I had been on notice of it, I would have filed a summons that the court declared it to be an abusive process. And then, Gordon starts rolling his eyes that I'm being overly fucking technical, like I always am. So he basically makes indemnity orders against us because we had the audacity for being overly technical about procedural fairness requirements. And that if we had just put up with it, then ultimately nothing would have changed, even though they did the wrong thing. And he basically wanted to send a signal that being overly legalistic is, in his opinion, wrong. He was basically carrying on the gripe from the last fucking time that I had scolded him. So that's how we start off. And then it basically continues. So on the 5th of December, 2023, I ask him first. I tell him that I have discovered evidence through subpoenas and other proceedings that they've been writing to all the judges. It was a very short list of judges. He was on the list. So I have a reasonable, and they have admitted that they have written to everybody. So first, because the evidence had been discovered by subpoena in the other proceeding, and after the evidence had been discovered, there hadn't been a next hearing in that matter. So the documents had not entered the public domain because they hadn't been discussed in an open hearing yet. So we sought release from the Harman undertaking. The Supreme Court can give you release on behalf of subordinate courts or other courts that it has supervision over. So it didn't matter that it was in a different proceeding. Because it's the Supreme Court, he could have given us release. And by the way, the other side had not put any conditions on the use of the documents, so it was clear that there wouldn't be any problem. And so we sought release from the Harman undertaking. The first thing Gorton asks is, do these documents implicate me? Literally. He says, do you say that these documents show that I have done something wrong, that I have communicated with the fucking LSB? And I'm like, not directly, but also I can't talk about it because if I talk about it, then I'm breaching the Harman undertaking and it's technically contempt of court. So he says, okay, but he says, but you still confirm that I'm not directly implicated in this, right? I'm like, yes. So he tried to argue that because we were also bringing an application for his recusal at the time on the basis that he may have had communication with the LSB. So he was like, can you prove that I was talking to them through these documents? And we asked him to confirm whether or not he had engaged in communication with the LSB about the complaint, because we had a clear idea that he had. And he didn't tell us. We thought he would at least put it in his reasons. Now, I'm using this opportunity to attack the LSB mercilessly. They had a barrister who's not a complete fucking sellout, Marie Norton, I think. So Norton offered to produce the documents to the court on LSB's behalf because it was communication between LSB and Victoria Police. We had subpoenaed the police to get it. The LSB still have those documents. And I kept taunting them that, the LSB has, they can just release them. So Norton once offered. Then Gorton criticizes her. Does not let her put the documents in. Now, the excuse he uses at the time is that it will basically waste the court's time in going through all of these documents. And then Mazaris, who's basically the instructor and sitting behind. So Norton did this, by the way, on her own discretion because of her obligations, which I was constantly reminding her of as an officer of the court. And then when Gorton criticizes her, she says, okay, I'll seek instructions. And then Mazaris basically tells her not to. So we instantly knew that something was up, because why would Gorton stop her from releasing the documents of the LSB's communication with the court? In his reasons, instead of answering the question about whether or not he had had any communication with the LSB, Gorton notes that he says, to my credit, I made it very clear that I didn't have any evidence of Gorton communicating with the LSB. That's what he says, instead of clarifying whether or not he had actually had any communication with the LSB. So that's the first thing. Now, we know that he's crooked, and we have to basically prove it, but we have to set him up on a number of things first before we can do that. So we start subpoenaing the LSB for all their correspondence with the courts, and especially any complaints, because the point is that under the uniform law, Peter and the firm had the right to be advised of every complaint that had been made against them. Gorton rules that it's irrelevant whether or not or who had made the complaint. Because what we're basically arguing is that the LSB has taken the wrong decision or decisions. That's not what we were arguing only. We were arguing a bunch of other things. So he first decides that in a judicial review proceeding, he shouldn't decide all the other things, purely out of discretion. Then he says that now you're only arguing that they have made the wrong decision. So first he argues that all the other things should be dealt with in a tort law proceeding or something like that. Not here, because this is judicial review, it should be focused on the mistakes that they've made. Then he argues that because we're only arguing about their mistakes, it doesn't matter who incited them. Ultimately, it was their responsibility not to be incited. And then, on that basis, he rejects all the subpoenas that we were wanting the court to issue. Now, again, that's completely unlawful, because the law about subpoenas is that even if the evidence they produce is not admissible or relevant, you can still subpoena it, so long as you can present an apparent benefit that it can give you. The most conventional way of doing it is to attack the credibility of the witness. So if we could say that we can use the subpoena to demonstrate that this person had an improper motive to make decisions against us, this person at the LSB, because this judge was influencing him or whatever, then we can still use it. So now Gorton rules that we can't test the credibility of the witnesses. Literally, he ruled that. He ruled that we cannot attack the credibility of Anstey in relation to the notices that he issued. Because in his view, Anstey's credibility is not a fact in the proceeding. I don't even know what the proceeding was about anymore. Because we were alleging that they had done something wrong, which Gorton had a responsibility to assess. We basically positioned everything from an angle of discovery of evidence. I had to pull a lot of fucking maneuvers to argue that. Every time I would successfully make an argument, he would cut short the proceeding so as to exclude the discovery of evidence. And all this while, what he kept doing was making indemnity cost orders against us on lump sum, enforceable immediately. So the LSB could then charge us hundreds of thousands of dollars, like close to $500,000 they've already been claiming. And then, as was clearly the fucking intention, they issued bankruptcy notices against all three of us, and they issued 9 bankruptcy notices about the same orders. Okay? Clearly, to discourage the thing. And not only did they do that, what they did was they first issued the notice via email, then they issued the same notice via post. The service via post said, you now have 21 days. And the email had been sent 10 days earlier. Okay? So we applied to set aside the notices in accordance with the date that was set by the post. Then they came back and argued that we had committed an act of bankruptcy because we didn't apply in accordance with the email that was sent 10 days earlier. Even though the service by the post said that we now have 21 days to set aside these notices. The same fucking notices. And they did some other fucking stupid things. So that's the proceeding before the federal court now, that they're arguing that we still committed acts of bankruptcy because of the thing. Now, I was actually pretty excited about the proceedings because I knew that there I could subpoena the correspondence between Gorton and the LSB because we were going to attack it on the basis of fraud, that the decisions were fraudulently obtained. And there was a number of things. So one of the clearest things was that he had prevented me from cross-examining Anstey and ruled that the credibility of the witness was not something that was an issue in the proceeding, so we could not cross-examine him on credibility. So I don't even know. So what Anstey had done was literally produce a certificate himself, signed it himself, saying that he thinks that there is a proper basis to suspect that the firm is breaking the law and Peter Ansel is not doing his job, and therefore he appoints this investigator to investigate the matter. Then he affirmed an affidavit saying that there was this certificate on the record of LSB in relation to the firm and Peter Ansel, and on the basis of that certificate, he had taken the decision to do something. So he fucking produces a certificate, exhibits that as documentary evidence. The certificate doesn't allude to anything else except his own reasonable suspicion. So Gorton determines that because he's simply producing documentary evidence, his credibility is not an issue. And, there's a whole argument where I'm saying that he's the maker of the fucking the certificate. And then I cite to him the sections of the Crimes Act and all the other things that Anstey could have potentially breached in falsely certifying the document and so on and so forth. The LSB counsel is not taking objections. Like some of the things he's fucking shocked that Gorton was literally guarding Anstey with his life. The moment we would ask something, he'd say, I object to that. Immediately. And I pointed out several times, I said to him, and I'm literally quoting this, I told him that I will take all of these interactions, put them through a software program to show that he was acting fraudulently, and his pathetic desperation will be demonstrated as a matter of objective fact. I pointed out that McAuliffe, the counsel for the LSB, was not raising these objections, and so on and so forth. He didn't even hear me. That's how nervous or anxious he was. Never fucking correct. I mean, I said fuck, I don't know how many times during that hearing. Didn't even fucking, bat an eyelid about that. So at the next hearing, I had come there determined to, hold him to account. So I basically accused him of being a scoundrel and a scourge on all judges, honest judges everywhere. And then I told him that he had no option but to charge me with contempt or determine that I had made those allegations on proper basis because it's not about his honor, it's about the integrity of the court system. he said, well, so what you're saying is that anybody can, it's that easy to get rid of a judge because when I charge you with contempt, a different judge takes over and so on. And I reminded him that criminal contempt, can incur an imprisonment of up to 2 years or whatever. And if I really wanted to get rid of him, I would just punch him in the face or throw the water bottle at him. And, because I don't have a criminal record, the minor assault thing would be a much lower penalty than the criminal contempt. So I told him that no judge has a right, and if someone wants to really get rid of a judge, they can, if they're willing to commit crime. This is, by the way, on the transcript. So it was just completely ridiculous to say that we would commit a higher crime to get rid of him. And he didn't have a response to that, obviously. But the point is that I again repeated the allegation at the time that he had done all of that to protect them because he had been conspiring with them, and he must produce the documents that regarding his communication with the LSB. Again, refused to address that, refused to even address that in the reasons. Didn't even mention that I had alleged that he had been conspiring with them. Now, after that, he basically finds that, Peter, that their decision to not renew Peter's certificate was had operational effect. He's now going to assess whether or not it was lawful. He didn't even explain how that would reconcile with the operation of Section 462 of the Uniform Law, which basically says that if a decision is unlawful, it's ineffective as of the date on which it was made. So his position is that until he determines that it's unlawful, it's taken to be effective. And when he determines, or if he determines it's unlawful, then it retroactively applies, which is completely fucking stupid. Because in the interim, he's determined that Peter has committed a criminal offense. And I have committed a criminal offense, in effect, by relying on Peter. And, I mean, it's not that, because this is a civil proceeding and it's just declarations, so it's not a criminal offense in the standard sense that we'd have a criminal record, but he's granted injunctions on that basis, on that finding of fact. And it's on the civil standard, not on the criminal standard. So, anyway, we recently, when we applied to the federal court to subpoena the correspondence between the two bodies, they opposed the subpoena, so we filed an FOI, so we could use it in support of our subpoena application, because they were going to object to it, and we would say that, you see, there's communication, and that obviously cannot be good, because he's the judge in the matter. So therefore, the court should release the subpoena. When we FOI'd the thing, they immediately opposed it, as I had predicted. And we had been continuously asking Gorton for the correspondence. He wasn't giving it. This time, we wrote to him with the... he wasn't even responding to us. Not that he was not giving it. And this had been going on for over a year. So this time, we wrote to him with the LSB's FOI rejection. And we basically copied the Attorney General and the Chief Justice, and he wrote back and he basically said he's not going to entertain any further communication on the subject anymore. And then I wrote to him and I said, I told him about the law in respect of that he had an obligation to provide us with the disclosure. And we also asked him for reasons why he wasn't going to entertain any communication about this further. He says he's not going to give reasons. And then that was a clear problem, because a judge cannot refuse reasons. It's a jurisdictional error. It's a fundamental attribute of judicial power that the reasons are given. So the LSB has been basically writing to every other, writing to the court in relation to every other proceeding that we have, advising them, and they're fucked in those proceedings. They've already lost because some of those proceedings relate to subpoena applications that they had improperly resisted. And then I started the proceeding here, but at the same time, I kept on fighting in the same proceeding for those for the discovery of those subpoenas, because interlocutory decisions don't have an issue stopper, and I succeeded. And the following magistrates, or in some case judges, when they saw the communication, they thought that it was obviously unlawful and was potentially arguably criminally inciting the police, and they released it. So we've already won those proceedings because they've not challenged the decisions in those cases, subsequent decisions to release the subpoena, and we're only seeking review of their decision to oppose the disclosure of documents which they could not have lawfully opposed pursuant to the objectives of the uniform law. And secondly, Rapke was my lawyer, or at least former lawyer, after he ceased to act on behalf of the firm, and he was opposing the subpoenas after the ceasing to act was filed. But anyway, so those are the declarations we're seeking. So they're already fucked in those proceedings. So they're writing to the judges in those proceedings and saying that they expect us to be bankrupted, and so the proceedings should be stayed. That's the content. They recruited the corrupt judge to basically prevent the disclosure of documents and make all sorts of exorbitant cost orders on lump sum basis enforceable immediately, interlocutory matters where we've not done anything wrong. And he's basically made those orders to allow them to issue these bankruptcy notices. And the other thing that Gorton has done is he has influenced another judge. Now, this is about the IBAC complaint that we had. So Ganey had basically ruled that IBAC fucked up in not investigating the matter. He did that in response to the summary dismissal application. And he said that the only thing that's uncertain right now is the audio recording of the police, that we have that implicates them in serious crimes. And so therefore he cannot conclusively decide the matter. But that's the only uncertainty, because the IBAC had not accepted the authenticity of the recording, even though the police had in the other proceedings. Anyway, the IBAC had a clever idea of revisiting their decision because it was made on jurisdictional error, so they could just reopen the complaint. But in reopening the complaint, they were conceding that it was a jurisdictional error because that's the only circumstance in which they can revisit the decision. This is laid out in a High Court authority called Minister of Immigration versus Bharadwaj. So basically, the IBAC then brought an application that because we were seeking effectively what we were seeking was that they investigate the police, and because they had improperly rejected our complaint. Now that they've started investigating the police pursuant to our complaint, the proceeding has no benefit and should not be decided and dismissed without a decision being made. Gorton spoke to the judge who presided over the matter to accept that application. She got caught. She admitted it during the proceeding because basically she was doing some very stupid things in relation to interlocutory matters during the same hearing, and I put her on notice of the unlawfulness of what she was doing, and I told her what had happened with Gorton. And then she basically said she had sought instructions from him in relation to how to deal with me. And she repeated the steps that he had taken. So the steps being, when I raised the recusal application, She said that she would not decide the recusal application on the spot, as she's required to. She made substantive decisions in the matter about interlocutory applications, but deferred the hearing of the recusal application to a later stage, which she would decide on papers. So this is basically what Gorton had started doing towards the end. And she confirmed that Gorton had told her that she should act in that way because of his experience with us. And the orders were basically the same that Gorton had made. Even the time frames that he had given, same. So we obviously wanted Gorton's communication there as well because, there's a conflict there. So our position is that because Gorton, all these matters involve the LSB conspiring with the police in different capacities, and so we're subpoenaing all their communication with the courts and the police in all the proceedings. And Gorton has to basically obstruct that because otherwise he gets exposed. And therefore, he incited the judge to determine that there was no point in deciding the application anymore because the IBAC had already acted upon our thing, and it would just be a waste of time. And then she came up with a clever ground of her own, which was that it may even create problems for the IBAC's investigation because she may have to make findings of criminal conduct on behalf of Victoria Police while the IBAC is still investigating them. IBAC hadn't even fucking raised that ground in the submissions. And by the way, so we said that Justice Ganey had said that the only thing that needed to be determined was the veracity of the evidence of the recording of the police officers. And again, to conveniently take away that point, IBAC then admitted the veracity of the evidence. So after IBAC admitted the veracity of the evidence, we had won then. She ruled against Ganey, and she clarified that she was allowed to rule against Ganey because this was only a preliminary thing, and she doesn't think that there's any point. And she also ruled that, in her view, the only reasonable explanation why we're doing this is to embarrass the IBAC so we can publish about it online. And she considers that to be an abusive process. So, and this is obviously, Gorton inciting her because she was only there for 2 days and she knew everything about everything. So that's basically the crux of the matter in relation to the proceedings against the LSB. Now, what we're alleging in terms of contempt are the following things. One, they seized our files from the firm and then gave them to the police. We have discovered correspondence between police officers. So the police officer who had accompanied the LSB on the day that they took over the firm to basically stop people from resisting or obstructing them, he wrote an email to the informant in the proceeding, and he basically said that the LSB has seized all my case files in that matter, and if he wants a copy of those, of all the files that I've been maintaining in the proceeding against the police, then I should contact Howard Bowles. This is Michael Howard, the police officer. So that's one specific charge of contempt. The second charge is in relation to the LSB proceeding. The third charge is in relation to them pressuring Peter to... So what the LSB did was they forced Peter to sit for an examination, the purpose of which was to get access to documents that were protected by client legal privilege. And Peter told them that we had already lodged an application in the Supreme Court challenging the lawfulness of Gordon Cooper's appointment. He was the guy who had produced the notice to produce to Peter. So the LSB contacted the Prothonotary, told them that Peter's practicing certificate had been suspended, and so the application should not be sealed by the court. because one of the applicants was a company, the firm, and under the rules, the firm cannot act without a lawyer. So the prothonotary, in rejecting the application, gave reasons that Peter's practicing certificate has been suspended. Then the LSB applied to the court to say that Peter was unlawfully resisting the notice to, the examination notice. Peter said that he had already lodged the proceeding. The judge asked the other side if that was true. They said they have no idea, even though Peter had given them a copy of the originating motion that he had lodged, based on which they had contacted the prothonotary, which later came out. And then the judge proceeded on the basis that there was no evidence that Peter had lodged the proceeding. And then, made orders that Peter has to comply with the notice to produce documents and to give evidence about the client privilege material. So that's the third ground of contempt, that they disrupted or interfered in the commencement of the proceedings. The prothonotary later admitted that he was at fault and sealed the document after their proceeding had first been commenced, and the judge was prevented from knowing about our proceeding. So those are the three charges of contempt that we are filing against different officers in the board. And then besides that, we're basically going to seek declaratory relief against a number of people, including Joanne Jenkins and Fiona McLean. And we'll rely on some of the matters that Thomas has raised. So that's basically it. I'm going to end this call shortly now, and I'll speak with people individually about any questions they may have. Glenn, are you still there?
Yes, I am.
Okay. Listening. Yeah. For what it's worth, I wanted to say that I think by now you should know that what people's opinion matters little to me at face value, unless I can identify a legal or other basis for what they're saying. And I know more about these things than anybody else does. So I think you should proceed on the basis that unless there is specific reason to believe what I'm doing is wrong, that I'm right. And that's in relation to the factual matters. But again, I've prepared for these things more than anybody else can physically do because of the hours that I put in and the things that I know. And we produced a number of authorities to Gorton which were exactly contrary to what he had done. And the recent decision in Tricario that came out, I think 2-3 days ago, again, Justice Gray did the same thing that we've been arguing should be done, and set aside the decision to suspend the practicing certificate, and it was enforceable right from the beginning. Anstey was the witness again, and because the judge wasn't conflicted, his credibility was very much a question, and he was required to produce all the documents that he had relied on in making the decision that he had made, which Gorton prevented us from doing. And based on those documents, the judge found that Anstey did not have enough to form a reasonable suspicion in relation to the matters that he had a suspicion about. So, I mean, the joke in all of this is that I could have punched Gorton in the face, and he would have said that he fell on my fist, face first, just to prevent me from being charged with contempt. And you were asking about what the relevance is of people's opinion and so on. Listen, I'm going to put in the affidavit, in the proceeding, that LSB has been screwing over a lot of people, and I have agreed to help all of them, so long as they all give their honest opinion about Gorton. I'll put it in the affidavit that I will, when I have enough time, hire people to stand outside the fucking State Library of Victoria, play clips about Gorton's proceedings, and tick boxes about whether he's a scandalous and corrupt judge or not. There is no, and I have already advertised all of that to Gorton. And I have told him that he should warn me or express any issues if he does have, as would be his duty, to protect the dignity of the court. Because, I mean, as far as I'm concerned, first of all, sub judice would not apply in this matter, or scandalization would not apply because it's honest and it's sincere and it's factual. But I've also advertised all of these things. And he has ruled that I genuinely believe that he's a scoundrel. He's already ruled that, so I cannot be charged with contempt in this matter. Because the law is that if you genuinely believe that a judge is a scoundrel, or a traitor, or whatever, then you're not at fault for, you have under the Charter of Human Rights and Responsibilities, you have a right to express your conscience, unless a law explicitly prohibits it. I can cite authority, Attorney General of South Australia versus City of Adelaide. There, the government had sought to pass regulation which prevented people from cursing in certain areas of the city. And the High Court found that people have a right to be abusive because it's not just about the words, it's about what the connotation is. It's an expression of anger. And people have a right to express themselves in whatever manner that is lawful, because it's an artistic expression of people's rage against the government. And that's a necessary element of the democratic checks and balances that the Constitution puts on the government. So I am going to bring a declaratory relief motion against the Attorney General I've advertised, because I think that they have an obligation to either charge me with contempt or join themselves in the proceeding to seek Gorton's recusal. Otherwise, they're scandalizing the affairs. So I haven't done that yet because I haven't applied to join them in Gorton's proceeding yet. I will do that, and if they don't take up the opportunity, then I will seek a declaration against them too. So nothing that I'm doing is subtle about this, and if Gorton is a danger to the rule of law.
The Attorney General can be invited to intervene, and I agree with you, Shivesh, that the police officer providing access to your defence files to the prosecuting informant was in contempt of court. Now, and that has been a complaint that you have made to IBAC, and IBAC have refused to investigate.
Because of Gorton's decisions, that's right. Because of Gorton's decisions in the matter. So the IBAC basically, first, they refused to investigate, and they notified me of that. Then, after they made the decision that they had fucked up in not investigating the police, they, of their own motion, reopened the investigation into the LSB, told me during mediation that that was just despicable, and they were going to go after the LSB for that. But then Gorton came in and made all sorts of decisions and basically said, what's the point in a judicial review court making all these sort of tort law sort of declarations against the LSB? And he was not going to do any of that. So that emboldened the IBAC, because they know that the moment they the moment they investigate the LSB, I'm going to sue them for misfeasance by admission that they had done the wrong thing, which is what I'm doing in relation to the Victoria police matter. So they're fucked if they do, they're fucked if they don't. They're just counting on the fact that Gorton will crush me. This was before they realized, they would have known that I've got Gorton in a bind. But in the contempt proceeding, I'm also going to, or in related proceedings, I'm going to sue IBAC for not investigating Gorton. or dismissing the complaint against Gorton. They dismissed my complaint against Gorton on the basis that because he had made judicial decisions. So under the IBAC Act, the exception for corruption allegations against the judge is if they've made decisions that are within the realm of error of law, the IBAC is not to investigate them in that respect. But that's not what the allegation was. The allegation was that he had communicated with the police, with the LSB, and then sat on the proceeding.
Yes.
Yeah, but they didn't do that because they said that all they know is that he hasn't released the he hasn't commented about the communication, and that's basically a judicial decision.
Well, of course he wouldn't.
But now he has admitted it.
That's the whole point.
But now he has admitted it because I put him, and the next email that I wrote to him basically said that because it would be even worse if he hadn't communicated and not clarified that he hadn't. Therefore, I'm going to be more abusive to him because I have a duty to force him to respond. And then I told him that the only, more than anything else, the good thing about him getting caught is that I don't have to pretend to be respectful to him in court because he's a piece of shit.
All right, very well.
So the point is that the IBAC was required to investigate whether or not they had communicated, and it has subpoena powers of its own. I mean, I don't have to give them evidence of culpability when I make a complaint. So long as it's made on reasonable basis and there is a preliminary basis to investigate, they have to investigate and discover the facts on their own. Do you understand what I'm saying?
Yes, I do. Yeah. Look, I understand, and look, I for one, happy to continue to liaise and engage with you.
Sorry?
I agree.
Yeah. So now Gorton is basically, he has gone underground. He's not scheduling any further hearings in the matter. I think he's just praying that the LSP would somehow succeed in the bankruptcy matter, which I think will be dismissed shortly now after we issue the contempt proceedings. The other problem is that their lawyers, who we are also joining in the contempt proceeding, cannot act for them anymore because of the solicitor conduct rules. There's no other lawyer that they can find to take over the matter. I mean, they're having a hard time getting barristers because after the end of every hearing, I'm putting the hearing on YouTube and I'm basically attacking the people during the hearing. So every hearing, they have a new barrister, and it's generally the lowest barrister who was admitted. Like, the guy who was admitted.
Yes, I understand that because nobody wants to be involved.
Exactly.
So they can earn easier money elsewhere.
Exactly. So they're not going to be able to continue the proceeding. No solicitor will take this matter on after this. And I mean, it's a scandalous matter anyway. So that's basically the crux of it. And I think everybody has an obligation to...
And can I just ask, whilst we've got the group here, in terms of is Peter applying for his practicing certificate or the period of suspension that he's not able, the effective suspension, that he's not able to apply for a practicing certificate? Is that going before VCAT or is...
No, so we're seeking judicial review of the decision not to renew his practicing certificate.
When is that going to proceed?
That was before Gorton. So it's part of the proceeding that Gorton is not doing anything about.
And so...
It was lodged on the 6th of October or 14th of October, 2022.
And what was the period that Peter, if I could ask on your behalf, Peter, you weren't able to reapply for a practicing certificate for?
Since 18th of October, 22.
Was he cancelled, not able to reapply?
18th of October, 22. 18th of October, 22 was when his license...
I understand, but then there'll be a period not to apply for a practicing
No,
certificate?
no, because there was no decision made in his case. So what they did was they didn't suspend his license, which we are saying should have been the right way. They're just not letting him renew his license.
Yes, I understand.
And they
so-
haven't told him any period for which he cannot renew it. They're just not processing his application.
So he's got a deemed certificate whilst that is not being processed.
That's what our point is. But Gorton says that no, that's not what the law is, even though it is what the law is. So they haven't told him that he cannot reapply. They've just disabled the application button on his LSB profile.
But I think he's got a deemed certificate whilst that continues.
I know, that's our point too, but Gorton will not accept it because he says that this is a deliberate decision on their part because of
that is what they also did with me, with no explanation. Before any investigation or even complaints were made, and the complaints were orchestrated around that agenda, demonstrated by the deeming of my certificate and the refusal. I practiced on a certificate that wasn't renewed for a full financial year before any of this started against me.
Yeah, I know. They're doing this with a lot of people. It's not an uncommon thing.
Who else are they doing it with, and why? Who are those people?
So we get contacted by people that, so we're now collecting, we're now inviting people to contact us about their fights with the LSB. We've received a lot of contact forms. We're going through them as soon as we can, but it's taking us a while. But my understanding is that they're doing it with, as a general practice with a lot of people. I think with what they did with Tricario was in essence the same, in the sense that they received a complaint or they received notification that she had been charged without checking the evidence that the police had. They issued an automatic suspension. Exactly. Without even getting her to respond to the allegations. And they, after the suspension, so they never specified how long the suspension will operate or whether she can apply again or not. Nothing. They just suspended and they keep people in the fucking limbo. And that's what the judge found to be wrong.
And the reason why they do that is because
they don't have the grounds to apply for suspension.
They suspended me for 6 months, Shivesh, and I've taken issue with that. And since I've taken issue with that, they've suspended others for more lengthy periods. Nick Marsevsky, they suspended
Marsevsky,
him for,
was the partner of the lawyer.
Yes, 5 years.
Yeah.
And he hasn't, and despite the fact that he has not even been charged.
Yeah, I'm going to speak with Marsevsky and see if he's willing to cooperate with the thing. But basically, I think Daryl Nolch has the same complaint.
Yes.
That they've not told him that he can't apply for one, but they just won't renew his license. And then I think you also send me some other names as well. So unless people give me firm evidence, I don't take their name, till they authorize me. If you already know about them, I don't have a problem. But basically, until people authorize us to use their name, we will use the statistics of how many people there are. But after they authorize, then we use their name. So, and we can justify the statistics if they, subpoena us.
Because I have an application before VCAT that is running coincide with my disciplinary matter that just cannot get a hearing because VCAT takes the view that disciplinary matters stay your application for review of a decision not to grant your practicing certificate.
Yeah, there's no legal basis for that.
No.
In fact, one of the things that the judge pointed out in the recent decision is that because of... So, a preemptive disciplinary step to injunct someone against getting a practicing certificate is only justified where there is a likelihood that the same conduct will reoccur. And what His Honor Justice Gray found was that because what she was charged with was such a peculiar thing, the possibility of reoffending was very low.
Yes.
So, in Peter's case, they haven't even charged him with anything. But what they have to demonstrate is that the possibility of the person doing the same thing, if their practicing certificate is renewed, is so high that it justifies the preemptive stay of the thing while the matter is being decided. There is no basis in law for them to do that. Anyway, so the next steps, Glenn, in particular,
I can talk to you more over the coming days. Thank you.
Yeah. But I think if you want to be...
Shivesh, can I add something? We spoke last night about my matters in front of VCAT.
Yeah.
How they suspended me and then 8 months later made up charges after they'd taken the business and sold it all up. And then you said that I need to be careful on the 29th of May, that date coming up.
Absolutely.
Because my application they tried to dismiss through VCAT, which had been lodged before their June last year charges.
Yeah, so you know how I was talking about earlier the part of the brain that deals with social justice issues being different. So what the LSB does in particular is that it weaponizes prejudicial allegations very effectively. So they will try to introduce horrible accusations against the people. A lot of the times they have themselves manufactured those allegations to basically prejudice the mind of the member or whoever has to decide into thinking that, there is a high possibility or a reasonable possibility that this lawyer will do something improper, and then it's going to come back and bite me in the ass. That's a big part of their, modus operandi. That's one thing, but the other thing... Sorry?
Go ahead.
No, the other thing it does is if the member is already on their side, it gives them some sort of justification by repeating those allegations in their judgment. So that's the pattern of conduct that I'm talking about, that they engage in terms of interfering in the judicial process. And I think the proceeding will make other judges and members aware of it through the fact that those things are being alleged, and unless they can stop the proceeding from commencing, the fact of its existence proves that it is a credible allegation, and they couldn't get it kicked out on the basis of no evidence or scandalous thing or the other. So I think it will help everybody, and therefore it's in everybody's interest that they come forward and give evidence, not just against the legal services.
Shivesh, can I just add something further?
Yeah, sure.
Just a couple of general comments. And it's clear from what's happened in my matter and clear from reading material in other matters that the LSB, as you said, act fast and loose, and indeed act dishonestly. The issue that Shivesh mentioned about contacting the respondent directly was an extraordinary thing for them to have done, to deliberately delay our proceedings. So their MO is pretty clear, is to subjugate and hurt you so badly financially, etc., that they make you or neuter you in relation to what you can do and fight back. The other point I would just like to make in relation to my involvement with Shivesh over the last 2 years, I can guarantee you that I've never seen any person put so much effort into what he does, the hours he spends, the minute detail he goes into, is quite extraordinary. The fact that he's picked up a number of these matters, especially if we talk about the magistrates court matters, in which he managed to have all the charges dropped and argued those cases succinctly before the court, and indeed I think had a number of the magistrates in awe of the fact that they knew more about the law than they did was exceptional. Then the fact that he's able to argue very coherently and with good legal basis the matters before the Supreme Court, again, is testament to the amount of work that he puts into this. And I can't stress that more than that. It's exceptional in that regard.
Yeah, and I think, Peter, while you were talking, it struck me that because the LSB know that they have fucked up, that's why they never raised any objection to the recusal applications. All this while, we were wondering why they were never, Gorton invites them to oppose the recusal applications, and irrespective of how abusive I've gotten, they've never once raised any objection to the recusal application. It's because they know that they will get into trouble, because they have been communicating with Gorton. And right now, they're basically hiding behind him in the sense that if he decides that the correspondence should not be released, then he's a judge and there's been a judicial determination effectively. But they're playing it very fucking safe in never directly opposing the recusal application. But when it comes to cost orders, they're always there to seek indemnity costs on that basis. And they're also there to use...
So true.
Sorry?
I just said so true.
Yeah, and what they also do is raise those matters in front of other judges to imply that we're committing contempt of court, and they never even oppose the recusal applications. So it's all of these things can be used to demonstrate what's called consciousness of guilt. The Jones v. Dunkel inferences that can be drawn about their behavior. And what that does is it puts them then under the obligation to deny it explicitly on affidavit. I'm not sure if you guys are familiar with Blatch versus Archer. Have you heard of it, Thomas? Blatch versus Archer? The principle?
No, Shivesh, no.
Okay.
But I'll have to make a move soon,
Yeah,
Shivesh.
I'm gonna...
Can we talk separately later on?
Yeah, let's do that. I'm just going to end the call with this quote from Blatch versus Archer. All evidence is to be weighed according to the proof which it was in the power of one side to have produced and in the power of the other side to have contradicted. This is an ancient principle of how the court should draw inferences from Blatch versus Archer, 1774. It's a British authority of Chief Justice Lord Mansfield. Okay, all right. Nice talking to everybody. We'll no doubt keep in touch about stuff.